Today we are going over the listing contract, and we're also going to be going over a delayed listing and a MLS exclusion and a single party listing. Just quickly going over those to differentiate the three types, most common types. And I don't know what made me think of this morning, but I was thinking about when I first started selling real estate and how paralyzed I was by contracts and making sure that it was really important to me to be able to understand these, because when I got in front of a client, I just was really afraid of looking like incompetent. So I practice this a lot. So I just want to throw that out there, that get comfortable with explaining offers, explaining listing contracts, explaining buyer agency agreements. It's all, I think I was like scared of even like getting new business sometimes, because I was afraid of like this part of the process of a transaction, which is silly. So also just wanted to share that, because there might be some people feeling that as well. So but the residential listing contract, so this is a contract between us as the firm and the person, which may be an owner, maybe otherwise, in charge of selling a property. It's a service contract. We'll get right to it. Exclusive right to sell. So this gives us the power to sell the home no matter who brings the buyer. And that is what exclusive right to sell means. So if we procure the buyer, if a subagent procures the buyer, if another brokerage procures the buyer, if a seller themselves starts negotiating with a party, we are owed a commission if that is the case as well, if the seller procures their own buyer throughout the time of the listing. So that is what exclusive right to sell indicates. So just starting from the top, so seller gives the firm the exclusive right to sell the property on the following terms. So this is where you're going to put on lines 2 to 5 the property description. So you'll put the street address, and continuing on line 4 in the you're going to put the municipality type. So we'll say City of Milwaukee, County of Milwaukee. And just a note that you'll be putting the street address. So sorry, everyone. You'll be putting the street address in there. There's some properties that have different mailing or mailing authorities based on where the property is. Like if it's a township, you're going to put the street address here, not necessarily what the mailing address is. Just letting somebody in here. All right. So lines 6 through 11, you are going to indicate what is included in the purchase price. So sellers including in the list price of property, all fixtures not excluded on lines 12 through 14, and the following items. So here's where you will put things like appliances. There are various pieces of the property that a owner might be willing to transfer along. Beyond appliances, I would be specific here, and even if it is a fixture, maybe just still specify it so that there's no confusion when it comes time for an offer, and when you are transferring these items to the MLS data sheet to communicate to the buyer. So, for example, a big thing is window treatments. So, curtain rods, for example, are considered a fixture. And because they are considered a fixture, they would automatically stay with the home. But I would still specify curtain rods, as well as if the seller is willing to leave the window treatments themselves, the curtains. The curtains would be considered personal property in this case. But if the seller is willing to leave them, be specific and say curtain rods and curtains. Another big example that I get or see are mirrors in bathrooms that look like they should be attached to the wall, part of the bathroom decor that, could be a bathroom mirror, vanity, I should say, that's like built into the wall. I would include things like that as well, just so there's no confusion. And then on the flip side, if it's not included, making sure that we're specifying those things. I think a bathroom mirror where just like an owner picks the perfect size mirror for this space, then we go to do final walkthrough and it's missing. So just be specific. So lines 12 through 14 is when we're going to get into items not included in the purchase price. There's a caution for the seller here. Identify fixtures to be excluded by seller or which are rented and will continue to be owned by the lessor. So fixtures that, unless otherwise stated here, are automatically included. So shelving that is affixed to the wall is considered a fixture, and that would stay with the home. If the owner wants those things, we need to make sure that they are included in this not included in the list price section. Light fixtures are a big one. If there's a chandelier that is very important to the seller, we need to make sure that we list it here. I've seen people, owners want to take perennials that are very important to them, so we would list that here. And another comment about inclusions and exclusions on a listing contract, the best way to think of this too is this is what we're communicating to the buyer, that this is the seller's wish list of items that they want to keep and not keep. Ultimately, the offer, 9 times out of 10, the buyer is going to honor that and just, completely mimic what's in the inclusions and exclusions on MLS. But let's say, I think a dining room chandelier or something like that would be a great example of something where a buyer might see that and say, you know what, I would love to keep that. That's the perfect spot. That's a perfect light fixture for this space. A buyer can absolutely attempt to put that in an inclusion in an offer. And if the seller agrees, great, then it'll stay. So ultimately, the way that you can think about it is the listing contract is the wish list for a seller's inclusions and exclusions, but ultimately the offer is what holds. Any questions on that? Another comment to make, those items that are rented water softeners, we see that more out west in the western counties. If a seller is renting that, we need to make sure that we mark that down as an exclusion. Throughout the transaction, we could get the buyer in touch with the company who is renting the equipment to the owner, and maybe they can just continue service. But since it's not something the owner owns themselves, we need to make sure that's listed as a exclusion. Line 17, you're going to put in the list price. And just as a comment, in practice, I would say, when I'm explaining a listing contract to a seller, I think list price is probably the last thing that I visit with them. We'll go over through whole contract, and then we'll kind of revisit and do list price last thing if we're not sure yet. Kind of same with offer price is usually the last discussion point. Lines 18 through 20, so marketing. This is an authorization from the seller to the firm. So seller authorizes the firm and its agents agree to use reasonable efforts to market the property. Seller agrees that the firm and its agents may market seller's personal property identified on lines 7 through 11 during the term of the listing, and the marketing may include, and then here you're going to just list all of the things that you are, as an owner or as a listing agent, going to do for the seller. So more often than not, I will see, yard sign, social media marketing, networking, open houses, website syndication, multiple listing service. But another way to kind of wrap all of that into one thing is, marketing. Like I'll say Swinney and Associates marketing plan, and then I will just include what those things are when I'm conversing with the seller, and all of the things that I will do for them to market the home. Another thing to be wary of or to be cautious of is that anything that you list here, you need to adhere to. So, if you're going to say weekly open houses, you need to make sure you're doing an open house weekly. Line 22, the firm and its agents may advertise the following special financing incentives offered by the seller. We don't see this too often these days, but back, I would say 2010 through 2011, when it was more of a buyer's market, sellers were offering buyer's agent bonuses. So that could be something that you could list here. So the buyer's agent could receive a $2,000 selling bonus if they sold the home prior to a certain closing date. I'm sure that we'll see that again someday. Seller has a duty to cooperate with the marketing efforts of the firm and its agents. See lines 246 regarding the firm's role as a marketing agent and seller's duty to notify the firm of any potential buyer known to the seller. Seller agrees that the firm and its agents may market other properties during the term of this listing. So that's just another point for you, another checkpoint for you to say to the seller, again, if you procure your own buyer or if somebody comes to you privately, you need to refer them to me. And then just an acknowledgement that, of course, that we as listing agents have more than one listing. Commission. So lines 27 through 28 is where you will note our firm's commission. So the firm's commission shall be, 6%. If you want to attempt to go higher, 7%. Again, per our ICA, our independent contractor agreement, the lowest that you can go is 5% for a full market listing. And then often, because remember, we as listing agents have a $295 fee that we pay to the market center for every listing. This just applies to listings only. We will often attempt to make that a pass-through fee and put that on our sellers. Just a note here that $295 is what we owe to the market center, but I have seen people attempt to make this number higher, $495, $395. There are some agents who are charging $695 for that. So that's just more of a tip and trick for you to attempt. Most sellers, I would say, aren't even blinking an eye at that. So whether or not you charge that extra commission, we're, as a market center, are always charging the $295 to you. Okay. Lines 27 through 40. This gets into, 29 through 40. This section gets into and explains to a seller how a commission is earned. So a seller shall pay the firm's commission, which shall be earned if during the term of the listing, seller sells or accepts an offer which creates an enforceable contract for the sale of all or any part of the property. That is obviously the most typical way that we are earning our commission. Seller grants an option to purchase all or any part of the property which is subsequently exercised. Seller exchanges or enters into a binding exchange agreement on all or any part of the property. A transaction occurs which an effective change in ownership or control of all or any part of the property, or, and this one is probably the most common in that we might enforce this commission earned as a firm, which I liked this term, a mirror image of what the mirror buyer is what the term I had heard recently. So a ready, willing, and able buyer submits a bona fide written offer to seller or firm for the property at or above the list price and on substantially the same terms set forth in this listing and the current WB11, the current offer to purchase, even if seller does not accept the buyer's offer. So if you list a property for $200,000 and if you list a property for $200,000 and you receive an offer for $200,000 contingency free, seller doesn't accept the offer, it could be argued that we as a firm still earned our commission because a ready, willing, and able buyer was willing to purchase the home. It's just that the seller did not accept it. I will say that I'm not going to spend too much time on points 2, 3, and 4, just because we don't see it often in residential real estate. But typically, if a transaction or if a listing expires and an offer falls apart, we as a firm are not generally enforcing earned commissions. It's just not really great business practice. So
yeah, I'd like to add here, Steph. Sometimes a seller will get an attorney to review the listing contract, and these lines are all crossed off for an attorney who's representing a seller. And sometimes it scares the agent saying, can I do that? And we usually allow that. It's pretty common for an attorney to cross those lines out.
Yeah. Firm's commission shall be earned if during the term of the listing, one seller of the property sells, conveys, exchanges as described above, an interest in any or in all or any part of the property to another owner, except by divorce judgment. So again, just another checkpoint saying that no matter where this buyer comes from, we are owed a commission. Due and payable. So once earned, the firm's commission is due and payable in full at the earlier of closing or the date set for closing, even if the transaction does not close. So if we were to enforce that commission earned and it does not close, we would be owed that commission on the day set for closing, even if it does not close. Lines 43 through 49. This just describes on how the commission is calculated. So a percentage commission shall be calculated based on the following. If earned above, and then it outlines based off of how the property was transferred, how the commission is calculated. Typically though, it's the total of the purchase price times or percentage of the purchase of the final sale price. Thank you. When you're going through these with your clients, you don't want to get in too much into the weeds. So, we're talking in what's most typical. So, the commission is a percentage of the sale price. Compensation to others. So this is an explanation to the seller how we are compensating who brings the buyer. So the firm offers the following commission to cooperating firms. And you can name exceptions to that. I don't see that too often, but this is where our market in this area is typically 2.4%. When another just kind of tip and trick to the when you're explaining this to an owner, I'm generally tying this section in when I'm talking about the total commission, so that the owner understands that that 2.4% is coming out of the total commission here, and that it's not an extra 2.4%. And it just kind of also is a good way to kind of set the stage for how the commission is divided up between listing firm, listing agent, buyer's firm, and buyer's agent. And it makes this conversation about commission much easier. Buyer's financial capability. The firm and its agents are not responsible to qualify a buyer's financial capability. So, we're relying on pre-approval letters, proof of funds, and financing contingencies. Dispute resolution, lines 58 through 62. Parties understand that if there's a dispute about the listing or an alleged breach that the parties cannot resolve the dispute by mutual agreement, the parties may consider judicial resolution, or they may consider alternate dispute resolution. Generally, again, if it's not something that you can come to an agreement on with your seller, talk to Joan or I first thing. Fair housing. Seller and the firm and its agents agree that they will not discriminate against any prospective buyer on any of the protected classes. Now we get into the disclosure to clients and the duties that are owed to all parties in a transaction. Then we get into duties that are owed to a client of the firm, which are expanded upon from the duties that we owe to customers. And then we get into multiple representation and designated agency, which we went over a couple classes ago, more in depth. I will not go into multiple representation and designated agency so in depth this time around, but we'll talk about how as it relates to a listing as a listing agent. So duties to clients and customers. So we're at lines 67 through 80. So duty to provide brokerage services to you fairly and honestly, duty to exercise reasonable skill and care, and disclose to you any written certain material adverse facts about a property, duty to protect your confidentiality, duty to safeguard your funds, and duty when negotiating to present contract proposals in an objective manner. The biggest one that I would like to point out here, and the one kind of question that we'd run into the most, this duty to exercise reasonable skill and care in providing brokerage services to you. So we get a lot of questions about agents who, for example, would like to help a buyer, or service a listing up in Door County or somewhere, way out of our market, or list a commercial property. So this is where, we're constantly pointing back to this duty when we're responding to you guys on these things, that we as agents need to be servicing our clients in the best way possible. So, we're always going to be insisting that you partner with somebody on those listings that you would need to partner up, that you wouldn't know market conditions the same way that someone who works in that market consistently would. Dealing with different contracts when we're looking at commercial property, for example. So we take that very seriously. So please just understand when we have to kind of give you guys bad news on servicing something and potentially receiving full commission on it, that you do need to partner with somebody on it. Sometimes that partnering means a complete just referral to another agent in that market, and you'll receive a referral fee. Any questions on that? Okay, so because you've entered into an agency agreement with a firm, you are the firm's client, and these are the additional duties that we owe to clients. Firm or its agents will provide, at your request, information and advice on real estate matters. We must provide you with all material facts, including affecting the transaction, not just adverse facts. Fulfill the firm's obligations under the agency agreement and fulfill your lawful requests that are within the scope of the agency agreement. We'll negotiate for you. We will not place our interests ahead of your interests. And the firm and its agents will not, unless required by law, give information and advice to other parties who are not the firm's clients, if giving the information or advice is contrary to your interests. So when I'm going over this with a buyer or with a seller, I'm always outlining this section to them and making it clear that this is why you are entering into a listing agreement with me. I am able to give you advice, and I am able to negotiate on your behalf. Those are the two that I highlight the most when I'm going over this. And why, which will set us up for multiple representation. Why designated agency is so important, and why, I'm of the opinion that working as a dual agent, working as a agent with only the capabilities to act neutral in a transaction is counter to why people are entering into agency agreements in the first place. So multiple representation, relationships, and designated agency. Hopefully all of you guys were at that class. If not, it's on YouTube, but a couple of weeks ago, we went over right to cure and multiple representation more in depth. But in the case of a listing contract, a multiple representation might exist if another Keller Williams agent brings the buyer, and that Keller Williams agent has a buyer agency agreement in place with that buyer. So now a multiple representation agreement or multiple representation situation exists. And in the state of Wisconsin, clients must consent to that, but they have options on how they can be represented when that is the case. So multiple representation, I won't go over that again, I just explained that. But then it goes into identify and define what designated agency means, what without designated agency means, and the right of a party, of a client to just reject multiple representation altogether. So designated agency means that different agents with the firm will negotiate on behalf of you and the other client or clients in the transaction, and the firm's duties to you as a client will remain the same. So best way to quickly go over that. Joni, I have a listing. Joni brought the buyer. She's got a buyer agency agreement with that buyer. I'm in the ring boxing for my seller. Joni's in the ring with me, boxing for her buyer. And we are able to still provide advice to our clients, and still have the ability to negotiate for our clients. Without designated agency. The designated agency relationship is not authorized by you or other clients in the transaction. You may still authorize or reject a different type of multiple representation relationship. The firm may provide brokerage services to more than one client in the transaction, but neither the firm nor any of its agents may assist any client with information, opinions, and advice. Under this neutral approach, the same agent may represent more than one client in a transaction. So it can be done to write on your own listing, and become that neutral party. You're basically just kind of a paper pusher, and just moving the transaction along. But again, you're not giving advice or opinions or negotiating for any party in that case. If the client does not consent to multiple representation, the firm will not be allowed to provide brokerage services to more than one client in the transaction at all. So if my seller rejects to this notion altogether, then we will not be able to accept an offer from a Keller Williams agent who has a buyer's agency in place at all. Again, this only applies if the other party involved has an agency agreement, so that buyer agency must be in place. If, and taking Joan and I's example, if Joan had a buyer and was writing the offer as an agent of the seller, that's a different story. We can absolutely work with one another. So when explaining this to the seller client, they will be choosing which representation they would want. So that's on lines 113 through 115 and 118. And it's all spelled out very clearly for the client. So the same firm may represent me and the other party as long as the same agent is not representing us both. The same firm may represent me and the other party, but the firm must remain neutral regardless if one or more of the agents are involved. Or 3, the same firm cannot represent both me and the other party in the same transaction. I reject multiple representation relationships altogether. So if you're explaining this well, there should be no reason why an agent or a client would not consent to multiple representation with designated agency. You know, is how it would be working if it was a co-broke agent who brought the buyer client. So, and common, you know, we're hoping that we're, as Keller Williams agents, are selling each other's listings, right? So, any questions on multiple representation?
Yeah, I think you brought up the analogy of the boxing ring. I think it's a good one to keep in your own head, explaining that if the buyer's agent and the seller's agent are free to do their representation, they're in the boxing ring negotiating for their clients who are outside the ropes watching. If there's no representation because they didn't agree to that, you're putting the clients in the ring boxing with each other, and you, the agents, are on the outside of the ropes watching. Mm-hmm. So make sure that they understand the responsibilities of being an agent for the buyer and being an agent for the seller, and that they don't conflict. That's why the number one choice is the top choice, where they get the most representation and fairness of all of our clients, whether they're a buyer or a seller. Mm-hmm.
And explaining, oh, go ahead.
Sorry, I did have a question, but I wasn't sure quite where to place it. And you could wait to the end of this if you wanted to. But it's a kind of like in the class, or the classes that we took for licensing, they talked about modifying this contract for different purposes and uses. And the one that I was really curious to know if you could explain at some point is how to make it an open listing contract. Say my client doesn't want to limit themselves to just one agency, and they want to, you know, whoever gets the buyer gets the sale. So just kind of wondering if you could just, I think it's early on in the contract. I'm just, my instincts tell me it has something to do with how you would go over some of the earning commission stuff or whatever, but.
So actually, Joni, I would love it if you would tackle that, if you have experience with that. I don't know that we as a we as a company, I don't know that we have allowed that before. So it might be a non-issue because we.
Well, what it's called is, and Stephanie referred to it early on today, is the non-exclusive right to sell. So, and this, I'm going to talk about single party listings a little bit in tomorrow's team meeting. But a non-exclusive right to sell is a different form. And it does say that the seller can get a buyer from other agencies, other firms, other brokers. The buyer can sell it himself. But we as a company, as a firm, want to only use the exclusive right to sell. And that's a separate form. And that means that neither the seller can sell directly while it's being listed, nor can another firm sell the property while it's being listed. And this is where single party listings come in, which Steph's going to talk about a little bit. And I'm going to talk about again tomorrow, because single party listings are sort of getting tossed around quite a bit, and some of them are being tossed around illegally. So I think we have to realize the difference between the two forms, the exclusive right to sell and the non-exclusive right to sell. And Keller Williams does not want their agents to use non-exclusive right to sell contracts.
Okay, thank you.
Yeah. And then just a cautionary note for everybody. Well, I shouldn't say cautionary, it's not. Anyway, 120 to 124. So all clients who are parties to this agency agreement must consent to the selection checked above. So if you have, and I've seen this where a listing or an agency relationship might change mid-transaction. So let's say you have a listing contract and you do bring the buyer and both buyers agree to this neutral approach. If at first, well, first of all, both agency agreements need to reflect that the second choice without designated agency applies. So that might need to be modified mid-transaction.
And it would be an amendment to either the listing contract or an amendment to the buyer agency agreement that they're changing that form of agency.
Sub-agency. So this is an authorization from the seller. So your firm may engage other firms to assist your firm by providing brokerage services for your benefit. So a sub-agent firm and the agents associated with the sub-agent firm will not put their own interests ahead of your interests. A sub-agent firm will not, unless required by law, provide advice or opinions to other parties if doing so is contrary to your interests. So this is the co-broke agent. Another checkpoint for the seller, please review this information carefully. An agent can answer questions about brokerage services, but if you need legal advice, tax advice, or professional home inspection, contact an attorney, tax advisor, or home inspector. Another spot for us to gently remind everybody that we are not attorneys. So confidentiality notice to clients. The firm and its agents will keep confidential any information given to the firm or its agents in confidence, or any information obtained by the firm and its agents that a reasonable person would want to be kept confidential. The following information is required to disclose to you by law: any material adverse facts, and any facts known by the firm and its agents that contradict any information included in a written inspection report on the property or real estate that is subject to the transaction. And then it gets into a spot for sellers to identify anything that they want to make sure that it is kept confidential. So to ensure that the firm and its agents are aware of what specific information you consider confidential, you may list that information here. So on lines 147, you could, indicate those things that the seller might want to be kept confidential. So think a big example might be a divorce situation. Generally, I feel like these lines are, I haven't had to put much in these lines before.
I figure if it's confidential, why are you writing it out?
Yeah. Yeah. Lines 151 to 156. So this is the seller, kind of a provision for the seller. Parties agree that the firm and its agents will work and cooperate with other firms and agents in marketing the property, including firms acting as subagents. Cooperation includes providing access to the property for showing and presenting offers and other proposals. So this is just for the seller to let them know that you're agreeing to make sure that we can proceed with our marketing efforts. So we need to let people in. That includes showings and inspectors, of course. Note any firms with whom the firm shall not cooperate. Any firms or agents or buyers who shall not be allowed to attend showings, and the specific terms of offers which should not be submitted to the seller. So the usually what I see here is that there is a seller who's worked with a prior listing firm or listing agent that have expressed that they do not want them back in the property. That's usually what I see here. And you can note that on 156 to 157. Now we're getting into exclusions. So all persons who acquire an interest in the property who are protected buyers under a prior listing contract are excluded from this listing to the extent of the prior firm's legal rights, unless otherwise agreed to in writing. Within 7 days of the date of this listing, seller agrees to deliver to the firm a written list of all such protected buyers. So this is this is where you would indicate excluded buyers to this listing contract. So this is, those potential buyers that seller may have engaged with prior to listing the home with you. They could say to you, my neighbor expressed an interest in purchasing the home a couple months ago. If they come around, we want to exclude them from this contract and not owe you a commission if they purchase the home. More common though is if the home was listed prior to our firm entering into a listing agreement with the owner. Any buyer or potential buyer who viewed the home during the time that it was listed prior to our listing agreement becomes a protected buyer. So those protected buyers are typically protected for 12 months from the time that it expired. So sorry, let me backtrack. They're usually protected for 12 months from the time the listing expires, and then a year later. So if you are taking over a listing and that seller provides that list to you, we need to attach it to this listing contract. And then their previous listing firm is owed a commission if that buyer ends up writing an offer and the seller accepts that offer. So, and then to make a note about kind of those one-off cases where a owner was entertaining or attempting or started negotiation conversations with other random parties. It's definitely wise to kind of put a timestamp on that. So yes, Mr. Seller, we can exclude your neighbor for the first 2 weeks of this listing contract. And you would indicate that on line 164. So if they don't circle back around and commit to buying the home within that first 2 weeks, then they fall off this protected buyer list. Because arguably our marketing efforts could have kind of persuaded them to make that move. So definitely a negotiation point with a seller, but very important to put a timestamp on that. Does that make sense?
I would even move it up in this market,
Yeah. Yeah.
like 1 week or,
Mhm. All right, on page 4, we get into definitions. So adverse fact. So an adverse fact means any of the following. A condition or occurrence that is generally recognized by a competent licensee as doing any of the following. Significantly and adversely affecting the value of the property, significantly reducing the structural integrity of the improvements to the real estate, or presenting a significant health risk to occupants of the property. So kind of mirroring the definition of a defect. Or B, information that indicates that a party to a transaction is not able to or does not intend to meet his or her obligations under a contract or agreement made concerning the transaction. So this is beyond kind of those physical elements of the structure of the property. If you are in a transaction and you hear that a party is not intending to close, that must be disclosed. Deadlines and days. So deadlines expressed as a number of days from an event are calculated by excluding the day the event occurred and by counting subsequent calendar days. So if a transaction got accepted on Monday the 18th, then day 1 is Tuesday the 19th, and so forth. A defect. Defect means a condition that would have a significant adverse effect on the value of the property, that would significantly impair the health or safety of future occupants of the property, or that if not repaired, removed, or replaced would significantly shorten or adversely affect the expected normal life of the premises. A firm. A firm means a licensed sole proprietor, broker, or a licensed broker business entity. So I think it's important to actually distinguish these agency agreements are between the firm and the clients. It's not between the agent and the clients. So, if there are changes to these listing contracts, then significant changes, that they must be, they must go through Joni or I. A fixture. So, we can refer back to this definition of a fixture when we're going over our inclusions and exclusions of the contract. So fixture is an item of property which is physically attached to or so closely associated with the land or the buildings as to be treated as part of the real estate. And then it goes on to describe examples of a fixture. The best way, I think, to describe that is if you were to take these shelves off of fixed shelves off of the property, there would be damage, permanent damage to that wall. A light fixture, it would definitely need to be replaced. And obviously, another big example, I should actually bring this up. And we kind of stress these points with you guys because these are always the things that become points of contention in the last days of a transaction. So we just had a recent one where there was a shed on the property. It wasn't a it was laying on top of the ground. I'm sorry, on a cement slab. I think any reasonable person would have thought that that was included in the sale, and it wasn't identified in the listing or in the offer to purchase. So, we're going through final walkthrough, the shed is gone, and buyers are like, what? So the buyers did get compensated for that shed. So material adverse fact. A material adverse fact means any adverse fact that a party indicates is of such significance or that is generally recognized by a competent licensee as being of such significance to a reasonable party that it affects or would affect the party's decision to enter into a contract or agreement. So I think a big the example I like to use, like when showing a property, so we have a duty to disclose all adverse facts to our clients and customers. A material adverse fact, I feel like a good example of that would be those set of train tracks, where that might, if you're showing a property, there's a big set of train tracks a block away, that might affect a person's decision on entering into a contract or making an offer, I should say, on a home. Right. So it's kind of those things beyond just like component or structural issues with a home, right? Person acting on behalf of a buyer. So this means any person joined in interest with the buyer or otherwise acting on behalf of the buyer, including but not limited to the buyer's immediate family, agents, employees, directors, managers, etc. Property, unless otherwise stated, property means all property included in the list price. Then it goes on to define what a protected buyer is, and this comes under that extension of listing provision, which follows this. So a protected buyer means a buyer who personally or through any person acting on behalf of the buyer during the term of the listing delivers to the seller or the firm an offer to purchase, views the property with the seller or negotiates directly with the seller by communicating with the seller, attends an individual showing of the property or communicates with agents of the firm or cooperating firms regarding any potential terms. And a protected buyer also includes the person acting on behalf of the buyer joined in interest with or otherwise acting on behalf of the protected buyer. So let's say your listing expires and we need to put together this protected buyer list for the seller to make sure that if one of these people circle back around, we as the firm could collect that, we'll be able to collect that commission. So we need to make sure that we are including anyone who has seen the property either with us or with a other broker. So you'll get that list from your showing reports. This also includes anyone who the seller was in communication with. And obviously anybody who wrote or submitted an offer that didn't come together during the time of our listing agreement. But all of these people become what's called, again, a protected buyer. And if they circle back around within that 12 months, after our agreement expires, then we would be owed a commission. And that provision is extended or is in the next section. So listing term is extended for a period of 1 year as to any protected buyer. So upon receipt of a written request from the seller or a firm that has listed the property, the firm agrees to promptly deliver to seller a written list of those buyers by the firm and its agents to whom the extension period applies. Should this listing be terminated by a seller prior to the expiration of the term stated, this listing shall be extended for protected buyers on the same terms for 1 year after the listing is terminated. So automatically, if it expires naturally per that original expiration date, then that period starts at that natural expiration date. But if it is terminated early, then that clock would start ticking at that earlier expiration date. And now, Joni, I cannot recall if we went through this at, are these protected buyer lists, are we mailing these out?
Yeah, it says actually in the contract there to firm agrees to promptly deliver to seller a written list of those buyers known. It is to be, it can't be put on an email. It has to be a written, a written letter, and we have a form for that where the wording is already there and all you do is add the actual people who walk through or the names of the agents and the date and time of the showing to put through.
Right.
Is that what you were
So,
asking?
yeah, I actually couldn't recall if we as the compliance brokers needed to be signing these letters before they were sent out.
Oh,
I think we did
you're
determine
right.
that.
We do.
Okay, yes. So if you guys do have these, we have the form for you to copy the verbiage, add the names yourselves, and then they must come through Joni and I to sign before they're sent out. And good practice would be to mail it. That's the legitimate form, as Joni said, but we should email them as well, just cover all bases.
But email is not considered delivery of those names.
Yeah.
So you can do it as a gesture for the seller, but officially have to be mailed
Yeah.
and within 3 days.
I see that we're approaching 2 o'clock, you guys. Are you guys able to hang out with us for another 15 minutes?
Yes.
Awesome.
Yep.
Love it. Okay, thank you. Thanks, Karen. Okay, so moving on to the next page. Occupancy. So this is also covered in the offer to purchase. Unless otherwise provided, seller agrees to give the buyer occupancy of the property at the time of closing. And then this is just another reminder for your sellers that the condition that the property needs to be in when at closing. So property needs to be in room swept condition and free of all debris and personal property, except for personal property belonging to the tenants or any that the buyer has agreed to that the seller can leave with their consent. This, again, another point of contention that we see prior to, like, shortly before closing. Sellers need to understand the condition that their home needs to be in. So I'm always, I've got multiple checkpoints along the way with sellers. But that means free of old paint cans. That's probably the biggest thing that we get. Building debris. So remind your sellers, attics, garage, garage rafters, basement, all debris needs to be gone prior to closing. Leased property. So if property is currently leased, the leases will extend beyond closing, and seller will assign those sellers rights and transfer all security deposits and prepaid rents to the new owner. So that's all handled on the closing statement. Notice about Sex Offender Registry. If anyone has questions about this, any sex offenders in the area, they can consult this website. Our real estate condition report. This is a checkpoint for you to remind them that this is required in the state of Wisconsin to fill out the real estate condition report. It is a contractual obligation. So seller agrees to complete the real estate condition report provided by the firm and to the best of the seller's knowledge. Seller agrees to amend the report should seller learn of any defects after completion of the report, but before acceptance of a buyer's offer to purchase. So that's just a reminder to you guys, if you have an accepted offer and a defect is discovered, you're not amending the real estate condition report at that time. Either that's being dealt with the inspection report. If you're post inspection and a seller learns of a new defect, then or property damage, that is covered in the offer to purchase. Seller's representation regarding defects. Seller represents to the firm that as of the date of this listing, seller has no notice of knowledge of any defects affecting the property other than those noted on the real estate condition report. And this is a big, good old warning to the seller. If seller representations are incorrect or incomplete, seller may be liable for damages and costs. So just another opportunity for you guys to really stress how important it is for us, or I'm sorry, how important it is for sellers to disclose everything that they know about the property.
Hey, Steph, I have a quick question.
Yes, Alicia.
For the real estate condition report, for a trust, both daughters are on the trust. One daughter lives at the home currently. the other lived there when she was younger, are both required to sign the real estate condition, or just the one that lives there currently?
I would ask an attorney on that. I'm gonna
Okay.
point to that. I'm sure. Yes, but I don't think it would hurt to have both of them sign it.
Okay,
But
sounds good.
they're going to talk to their estate attorney.
Okay,
I'm going to say that again. They're going to talk to their estate attorney.
sounds good. Thank you.
Seller's cooperation with marketing efforts. So seller agrees to cooperate with the firm in the firm's marketing efforts and to provide the firm with all records, documents, and other material in seller's possession or control which are required in connection with the sale. Seller authorizes the firm and its agents to do those acts reasonably necessary to effect a sale, and seller agrees to cooperate fully with these efforts. So, seller, you're signing a listing contract for me to sell your home. We need to make sure that you have full cooperation with how we are, in effect, trying to get this home sold. Open house and showing responsibilities. So this is a hold harmless agreement for the firm. So seller is aware that there is a potential risk of injury, damage, and or theft involving persons on an individual showing or an open house. Seller accepts this responsibility for preparing the property to minimize the likelihood of injury, damage, and or loss of personal property. Seller agrees to hold the firm and its agents harmless for any losses of liability resulting from personal injury, property damage, or theft that occurs during an individual showing or open houses. So, my conversation around this is, obviously make sure that you are locking up any valuables that you have, put away any prescription medications that you have. If there's, decor that could be a trip hazard, making sure that that is out of the way. And that we as the firm are not held liable for anything that might happen on a showing or at an open house. Termination of listings. So neither seller nor the firm, and I love this section because it is the most confusing section. Neither seller nor the firm has the legal right to unilaterally terminate this listing absent a material breach of contract by the other party. Seller understands that the parties to this listing are seller and the firm. Agents for the firm do not, again, what I had said before, agents for the firm do not have the authority to enter into a mutual agreement to terminate the listing, must come through Joan or I. Amend the commission amount or shorten the term of this listing contract without the written consent of the supervising broker. Seller and the firm agrees that any termination of this listing by either party before the date on line 312 shall be effected by the seller only if stated in writing by and delivered by the authorized delivery methods. Or likewise, the firm, if we are trying to attempt to terminate a listing, we must deliver that in writing by the authorized delivery method. And affected by the firm only if stated in writing and delivered to the seller. Caution.
And the broker, it says there, but again, the broker has to sign that amendment to the listing contract.
Mm-hmm. Early termination of this listing may be a breach of contract, causing the terminating party to potentially be liable for damages. So it is confusing because it states that neither the seller nor the firm has the legal right to unilaterally terminate a listing. But then it goes on to give directions on how to terminate a listing earlier. So I just had to go through this with our attorney. And if you're going to have questions on this, you'll come to us, of course. But all this basically means is that one party does have a way to terminate a listing unilaterally, but it does not mean that they will not be held for damages. So hopefully that makes sense. Generally speaking, though, if a seller wants to terminate a listing earlier, it is not common for us to not abide by that or grant their request. So if you have any questions about that, give us a call. Earnest money. If the firm holds their trust funds in connection with the transaction, they shall be retained by the firm in the firm's trust account. And the firm may refuse to hold earnest money or other trust funds. I'm going to stop there because we do hold on to earnest money. It goes on to state that if there is a firm that does not have a trust account, that different agreements might need to be put in place for how earnest money is dispersed. All right. Thank you guys for bearing with us. Delivery of documents and written notices. So unless otherwise stated in this listing, delivery of documents and written notices to a party shall be effective only when accomplished by one of the methods below. So we've got, as we do in the offer to purchase, personal delivery, fax, commercial delivery, US mail, or email. 9.9 times out of 10, you guys are going to be using lines 297. You'll put the email address for the seller here on line 301, email address for the firm. You can put your own email there. Additional provisions. If there's anything that you want to add to the listing contract, you can use these lines. Any additional addenda that might be, if you're working with an attorney who might have their own addenda to add, you would place that there, or name that there, I should say. I don't think it's necessary to write in things like the KW disclosure. I do out of practice. I don't think it hurts anything. Term of the contract, 311 to 313. So you will name the start date here and then the expiration date on lines 312. Sellers sign on 317, 319, 321, or 323 if there's more than one or more than two sellers. If there's a seller entity, so maybe like an LLC, or as in the case of Alicia's listing coming up, the trust, they would sign on line 325. Sorry, they're going to sign on 327. You're going to name the entity on line 325. You as the agent are going to name, print your name on line 329, our listing firm, and then you're going to sign on line 329. So how this all relates to MLS, if you have a typical listing, it's not going to be delayed, it's not going to be excluded. You've got 48 hours to get it into MLS from the date listed on lines 311. And that actually is the case with a delayed listing as well, but we'll go into that in a second. Okay, so 48 hours, stick that in your brain, otherwise you get fined if you don't put it in MLS within that 48 hours.
And note that it's not the date that the seller signs on line 317.
Yes.
It's the date on line 311.
Yes. So that also will inform what date you put in there, because you'll need to have your ducks in a row, pictures done, marketing lined up, so that you'll be able to get all of this done and lined up for that 48-hour period. Make sense? Okay, so we're going to stick to the listing contract for now, and I'm going to go ahead and describe a single party listing contract. So if you have a single party listing contract, you are going to strike exclusive right to sell, and you are going to write in single party listing contract. You need to have names of interested parties who potentially want to show this, who potentially want to see this property prior to the execution of this listing contract. You're going to name any single party buyers and the additional provisions. And then you have the authorization for that showing to happen and for that party, that buyer, to see the property. I'm going to point Garen out for it here. He's got a single party listing right now. He had a single party listing opportunity, and they found a buyer to look at the property. They got that listing contract executed. The buyer looked at it. It was a pass for them. And now, for all intents and purposes, that listing contract with that buyer is done. If there are other parties who want to see this property, Garen needs to amend his listing contract each time to add that party before they show it. And this listing agreement only applies, the seller only owes us a commission if one of those parties named writes an offer and it gets accepted. So if you've got a single party listing contract, you are kind of in some rough waters in a way, in that this does not preclude another agent from trying to get their own single party listing contract with this seller. So Garen, I'm going to point you out again. Also because he's my mentee and I get to kind of get on his case a little bit. I'm pushing Garen to get, at the very minimum, an MLS excluded listing contract. He would be much more protected from another listing agent coming in and bringing their own buyer. So if you keep a listing contract, again, as a single party listing contract only, you have to keep amending the contract to add these names, and it's only valid if those buyers are named. Generally speaking, you're not kind of holding on to a single party listing contract and kind of doing this practice of adding listings or adding buyers. Usually how this is happening is, there's conversations between two agents who has one seller and has one buyer, and they come together and, they can execute this single party transaction without going fully out on the market. We're always explaining to sellers why that's risky. Again, we have a fiduciary responsibility for our sellers. But if it works out that they get their magic number and, we were able to find this buyer, it's absolutely fine to do that. But that's generally how it's working. We're executing this listing contract after the conversation between these two agents. An offer is written and we go to closing.
I have a question.
Yeah.
What advantage is this to the seller? I'm just curious.
In this, well, it doesn't bind them in a contract really for too long, in this case with Garen's listing, an opportunity for me to tell the story too is that, these guys were knocking on doors in a neighborhood, and they, all about privacy. That's one case. Garen made that comment in the chat section. They found this seller who was like, I would be willing to sell it. I'm not ready to go out on the market. I'm a private person. I don't want anyone to know that I'm trying to sell this property. But that also, in that case, having an MLS excluded listing would be more ideal for Garen in this case. So Garen's working on that, I know.
Yeah. Sometimes agents get a single party listing contract and then they feel that they could go out and fish for more single party buyers. And that's where it gets really risky, because unless they are adding each buyer as an amendment to this single party listing officially, they just can't keep pulling in prospective buyers and doing it on this contract. I mean, the reason the contract is called a single party listing is that it really is designed for a single party with the buyer. with the seller. So it really shouldn't be like fish bait out there for people to try and drag as many agents in who might have a buyer to do it. Get the listing. And as Steph said, better to get an excluded listing. Sometimes if the seller doesn't want to be fully out there, get an excluded listing, but don't fool around with adding lots of possible people to the single party listing.
Yeah. So if you do get that MLS excluded listing, you're going to use this accompanying form from MLS. And it should be in your listing packets on zip forms. So you're going to name the property address at the top. And then there's a series of statements that the seller needs to initial. Property will not be included in the MLS database. Metro MLS will not make available any information on sellers' property to other real estate websites. Real estate agents, brokers, and members of the public may be unaware of the availability of the seller's property and the terms and conditions under which seller is marketing the property. Reduction in exposure of the seller's property to other real estate offices may reduce the number of offers. So these are all kind of warning statements to the seller. You know, ultimately, MLS wants your property on the market, right? So it's just the seller needs to understand what they're potentially missing out on by not being out on the market. And then the statement on clear cooperation. So within 1 business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. So this is a warning to the seller that, you know, if it's excluded from MLS, it's absolutely, we cannot market it to the public. And we have gone over this in our some meetings, not too recently, but you know, there's this concept of clear cooperation, and a lot of people using this MLS excluded to you know, try and sell it themselves, an agent selling it themselves. So we've kind of run into issues with that. So this is just making it very aware to everybody that if this minute we start promoting this to the public, we need to get this into MLS. So if you have an MLS excluded listing, your hands are tied too, in a big way. I mean, we cannot put anything in writing to anybody about this listing. If you've got it, you can call people, but you're getting on the phone and you're calling them about this MLS excluded listing. So we don't want
social media.
No social media, nothing.
And
So
that even includes the Keller Williams Facebook page. I mean, you can sort of talk about it within your firm, but putting it out there on the Keller Williams Facebook page is also a risk. Because agents talk to other agents and other companies, and that's how they found out.
So is this typically the situation where the seller already knows who they'd like to sell it to? And they know?
No.
Not necessarily. You know, a big tool that this was used for was for that agent who wanted to get the property listed so that they had the listing agreement kind of secured while the property was still being, you know, while we were getting the home ready for market. And that's why the MLS then came up with that delayed status solution, which we'll go over next. And again, thanks to guys for hanging out with us. We're going over by quite a bit here, but again, also back to that privacy reasons, you know, just a seller who they don't want their neighborhood to know that they're, you know, selling their property. They're willing to sell it. They just don't want it out there. So, and Joni, just over the years, you might know better examples of why someone might want it excluded.
Yeah, MLS wants to make it very clear that it has to be the seller's wishes and the seller with informed understanding of what it means. What MLS is trying to prevent is our agents sort of trying to use it as their own pocket listing and having some advantage over other agents, other firms. And so if it's solely the reason from the seller, and that's why this form is so direct the way it is to the seller to fill out, they're trying to get rid of the idea that agents were trying to set it up so they could sell it themselves, or they could use it as a pocket listing. There are also some ramifications on fair housing and the way it's used on that too. And so we're trying to say, if you're going to exclude it from MLS marketing, that's what it is. And the seller has to realize that it's limited. I've been through many, many situations where it's been a risk. It's certainly not to the benefit of the seller, because the more competition on a property, the better the price and things like that. And sometimes the sellers are unaware of that. They're just listening to the agent and they're going along with what the agent says. And then sometimes, as a violation of code of ethics, the agent is doing it to benefit himself over his clients. So it's something that because we have delayed status now, it shouldn't be used for getting the house ready, and unless there's a lot to do. And a lot of times, like celebrities and sports figures like to have it excluded because they don't want the world to know. But again, make sure that the client is very aware of what they're doing and what they're signing.
So back to notifying MLS. So likewise, when you have a standard listing contract, full listing, you have to have it in MLS within that 48 hours. With an MLS excluded, we need to notify MLS within that 48 hours. So you'll just email it to them, all of the executed forms, to this admin@metromls.com as noted on the form, just to let them know that it exists. And I think there's a fine associated. I think it's a $50, not charge, I should say, for having an MLS excluded listing.
Right.
Okay, so if, let's say our real intention is to get the home ready. So now we've got that MLS delayed form. So you're going to use this in conjunction with the listing contract. And we need to make it clear to a seller that, we have to pick an exact showing start date. So I understand that the showings will not begin on my property until blank. So this is a different date than the start date of the listing firm, and different than the date of of when the seller signed it. So typically this is going to be a week to 3 weeks out of your listing date. And you need to have how do I want to phrase this? Like you need to be exact with when this showing start date is. You cannot move it up at all. So if you say 2 weeks out and the seller determine, oh gosh, we're done ahead of time, let's get this on the market, you can't move that date up. MLS will allow, though, if you need more time, but not longer than that 21 days, that you can extend it, push it out. So just again, some direction to the seller. Listing can be delayed from MLS for a maximum of 21 days from the start of the term of the contract as indicated on a listing agreement. Listings entered as delayed are searchable by members of the service and can be manually emailed to potential buyers. So the public is not seeing this. It is in MLS as delayed. And I can email out a link to my co-broke agents and have them share that with their buyers to let them know that it's coming, so that they can coordinate when to show it. But again, it's not on any websites, of course. While a listing is in delayed status, showings of any kind are not allowed. And this is kind of back to that clear cooperation. If we've had agents who have allowed showings on their delayed listings and they get in big trouble. It's a big no-no, big fine. Days on market begin the first day that the listing goes active. So it's not going to accumulate days on market during that delayed status period. Once a listing goes active in the system, the expectation is that it is available at the time for showings. So that showing start date, you cannot try and deny any showings that first day. We have to have a conversation with the seller, like once we pick the start date, then showings will begin on that date. I understand that during the time my property is in delayed status, MLS will not transmit information that my property is for sale to a third-party website. So no website indication, as I mentioned. The above mentioned date cannot be changed to reflect an earlier showing date than stated above. Once the property has been input into MLS, once the property has been put into MLS, delayed status cannot be extended beyond the 21-day period. So a repeat of what I just said. So in practice, you guys are going to get your listing contracts. You're going to get your delayed status form signed, excuse me. And then you have 48 hours to get that into MLS, as I stated, for a full listing. There is a status for delayed status. Then you put the showing start date in. But just like in a full listing, or just like in an excluded listing, the MLS will fine you after that 48 hours if they are not made aware of the listing. During that delayed listing period, you are able to market it as coming soon. So you can put it on your social media as coming soon. You can put it on Facebook pages, or personal Facebook pages and group Facebook pages, that it is coming soon. You can put a sign up. You just cannot show it. Very important. You cannot show it. Another thing to note, and this has happened in our crazy market, buyers may submit offers on delayed listings that they have not seen. So just be aware that if you have a delayed listing, you could receive an offer from a buyer who has never seen the property. That has been happening. Okay, I think we might have a wrap on all of this finally. I should have known that we would need more time than an hour. So, and again, sort of in practice, we went over this in more detail. I'm trying to pare all of the paperwork down to a client and explaining and summarizing everything in probably a half an hour to 45-minute period. So between the listing contract, between the real estate condition report, the lead-based paint addendum, and the Keller-Williams disclosure, and the home warranty waiver, those 5 pieces, practice this and get it all down in probably half hour to 45 minutes. No one wants to sit for 90 minutes like I just had you guys sit for 90 minutes. So are there any questions?
There's plenty, but I'm not going to ask them now. We've gone over long enough, I'm sure. Thank you, though.
If other people want to hop off, I'm happy to answer questions. So,
right, and make sure you call us anytime when you get stuck on some of these.
yeah.
I mean, the real secret to the answers that Steph and I give on these calls they're all in the contract.
Yeah.
It's just sometimes it's very confusing, it's very long, and sometimes kind of a twisted explanation, and we can hopefully untwist it for you. But
Yeah. Do you have a question that you have at the tip of your tongue? Go ahead.
I do have to go. So
Okay.
I've got a call.
Okay.
Okay.
Bye.
Thank
Thanks.
you.
Bye, everybody.
Bye. I was just wondering, has anybody recorded or done just sort of an example of how you summarize all of that in 30 minutes.
Oh, no, but I am just, like going over the definitions. So, I can skip that full page by saying, these are definitions that you'll find most common in a transaction. It refer back to this page, right? I think the only one that I really, and I'm kind of covering it, like with the defect, for example, I'm covering that when I'm going over the real estate condition report. Protected buyer, you're covering that when you're going over the extension of the listing contract. I just want to pull up the contract here again. I'm just trying to, where'd it go here? I'm gonna share again. The commission earned and so this first page, I mean, really, I'm talking about most common, what's happening most commonly to a seller. So the commission is 5%. It'll be based off of the final sale price. 2.4% of this 5% comes out or goes to the agent and the firm who brought the buyer. And it will be due and payable at closing. In my own practice, I am never, and I always say, if you want to terminate it's very rare for us as a brokerage to not honor a termination of a listing. So it would have to be kind of some weird circumstances for that to happen. So
would you say that when you're going over it, or would you just kind of?
Yeah, I mean, I kind of phrase it like, if there's a reason why you would want to terminate this listing, we'll have a conversation about it, but generally speaking, it's rare for us to not honor that. So, and I kind of make jokes in a way, like when I'm talking about dispute resolution. So, I understand that, if there's a disagreement between us at all regarding this contract, we could, go to court for it. I mean, it's just, but I kind of make a light of it and say, but we won't be in a situation like that. We'll know way ahead of that if it's ever going to get to something like that. Fair housing, disclosure to clients. So I say this, these first 7 duties are what we owe to all parties in the state of Wisconsin. Most namely the duty to provide services to you fairly and honestly, and the duty to exercise reasonable skill and care. And then I move on to, because you have entered into a client or into a listing agreement with me, you have become my client. And now I owe you additional duties, namely, and the reason why you have hired me is to give you real estate advice and opinions, and to negotiate on your behalf. And then I get in. Go ahead.
So I'm seeing the trend is you're picking out some really, really key things that need to be talked about or adhered to in the contract, and trying to just give it a really quick few words to describe it.
Yes, we need to, as agents, we're not able to interpret, we're able to summarize. So, I am going over each section, but it depends on how quick, the definitions though, I think is fine to refer back to, like, those are the most common definitions that you'll find, most common terms and their definitions that you'll find in a transaction.
You would never tell your customer or client to just, well, read this and let me know if you have questions.
No.
Okay. Just making sure.
Yeah. But then at that point too, to that warning to everybody that, you know, we're not attorneys. If you do have questions or concerns about this contract in any way, please consult with your attorney. So, yeah.
Okay.
I feel, you know, the section on multiple representation is a big section that can be summarized and handled in a minute or two, I would say.
So don't miss a section. Find a way to make sure that you hit all the key points.
Yes.
Don't miss any sections.
Right. You're going to spend more time on the bigger things. Multiple representation, the real estate condition report, inclusions and exclusions, I'm just going through this. You know, sub-agency. So you're giving us authorization to call on other brokers to help sell the property. Confidentiality. I owe you confidentiality in this contract, of course. If there's anything beyond that, you know, if there's anything specific that you want to make sure that we are keeping confidential, we can list them here. Exclusions. Is there anybody, have you had the home listed prior to us? And has there been anybody that has approached you or that you've been in conversations with who would potentially want to purchase the home? So.
Okay.
You can do it.
Going back to the whole signatures on the bottom, and you mentioned putting in the trust.
Yeah.
Is that essential, or would they still be able to sign under the seller's signature?
I would have them sign as the seller entity.
Okay.
So trustees of XYZ Living Trust, or, you know, however the trust is named.
Okay.
And then they'll sign at 327.
Okay, perfect. Thank you.
Anybody else? Okay.
Thanks, Steph.
Thank you guys. This is a long training, so I appreciate you sitting with me.
Thank you for doing
All right.
it.
Bye guys.
Bye.